Good afternoon. My name is Maurice Echols. I'm an attorney advisor for the Board of Ethics and Government Accountability. And today we're talking about, well, right now, we're talking about seeking, negotiating, and post-employment. Just a little bit of post-employment, but mainly seeking and negotiating. So how to do it and what could go wrong. Anyone here looking for a new job? You don't have to answer. But yeah, this is an interesting topic because I find that people are always interested in looking for a new job. But with that being said, just a little bit of general ethics advice. When it comes to seeking or negotiating employment, especially when organizations that do business, especially with organizations that do business with your agency, it's important to consult the Office of Government Ethics for guidance. This training focuses on rules around seeking and negotiating employment, but keep in mind that there are also post-employment restrictions that apply for varying time periods, should you leave your government office. That those restrictions relate to your former agent. And so what should be considered when we're on a deep search for a new tech? Now, I use slides that have this aquatic theme to it because what's the saying go? There's there's always other fish in the sea. Then it really is like an exploration. You're trying to see what's out there. Sometimes, going into a new job can be scary or just something you haven't seen before, or it can be quite beautiful. But any such, I just thought that it was, very similar to, exploring. And so we have like a little exploration theme in the slides going on. All right, so what should we consider? One of the main things to consider is a conflict of interest. So yes, this training is about seeking and negotiating, but the underlying issue is whether or not your prospective employer might create a conflict of interest in your current roles and duties, and what you should do to navigate those situations. And so while seeking employment, district employees must continue to follow ethics rules and avoid any conduct that creates or appears to create a conflict of interest with their official duties. There's a number of ethics rules that could arise while you're looking for employment. There's seeking and negotiating. Seeking conflicting employment is a violation in and of itself. If you have a decision or make an official decision that whether it benefits that prospective employer or not, that's a conflict of interest. If it does benefit the prospective employer and somehow you create a backdoor win for yourself, that's public office for private gain. So there's, in doing this, you could violate several, ethics rules and the violations for which the fines for which could be held or hefty. All right. So first off, conflict of interest that's found in DC Code 1-1162.23. Basically, engaging in official conduct that would affect your financial interests or the financial interests of a person closely affiliated with the employee. Employees shall not use their official position or substantially participate in a matter that an employee knows is likely to have a direct and predictable effect on the employee's financial interests or financial interests of a person closely affiliated, with the employee. And so that word closely affiliated is important there, right? As soon as you seek employment from a prospective employer, you're creating a relationship there. You could be seen as a closely affiliated person. That's where, or a closely affiliated entity, because you have some financial interest in the entity. So a conflict of interest could arise. And the same thing goes for indirect employee relationships with the entity that you might be seeking employment with. All right. So seeking employment typically marks the beginning of an employment process. An individual is considered to have started seeking employment if they have either directly or indirectly entered into employment discussions or negotiations with another person, reached out on their own to someone or their representative about potential job or opportunities, and then also responded other than a declining to an unsolicited job inquiry from someone or their representative. So let's see what that looks like. So seeking employment includes negotiations. Does anyone know what a negotiation is? I have a definition for that. Feel free to blurt it out or raise your hand.
Like if you need it.
Anyone have an answer? What's a negotiation? Basically, you're bargaining, right? You're bargaining for some type of promise. All right. So as soon as you ask or present, some type of future promise, or you're persuading them to consider a future promise, you're in a negotiation. And so when you express interest in a job, future employment, asking for future employment, persuading, showing them your resume, convincing them that you're able to handle the future employment, you're entering into negotiation. So an employee responding to a potential employer's interest, unless the response is rejection, you're sort of entering in the negotiation. You might not have said anything yet, but they put something out there, and you're mulling it over, like you're thinking about it. And so you're at that point, in a negotiation. So if you put your application out there, if you sent your resume to a prospective employer, they said, "Hey, we're collecting resumes, we're hiring," and you just sent your resume. They've seen you out and about during your work, and so they reach out and say, "Hey, are you interested in any future opportunities? We have a position, for you, and it pays this." You're now in a negotiation. And then if you didn't reject it, say, "Hey, I'm not looking," you're still in a negotiation with that prospective employer. So an employer is no longer considered to be seeking employment when either party rejects the possibility of employment. So you put your application in and they sent back, "Sorry, we don't need you." Then it's ended. But if the application is still, floating out there, and the job requisition is still open, you're still in the seeking process. And then also, if a reasonable amount of time has passed, so you put your application out there, but you didn't hear from them, it's been a few months later, you didn't even remember that you applied for the job, then you could be considered, no longer seeking. So with that being said, if you hadn't rejected an offer or withdrawn your application, how do you manage potential conflicts of interest with prospective employers that appear before your agency? Anyone want to answer that question right now? How would you manage that situation? So you put an application out there, or someone has offered you a position, and then you do make decisions regarding them in your official capacity. What you say? You said stop. We'll talk about it. I got one more slide, and we'll talk about, a solution we have for that. So I put this job here because, sometimes we may look like this, while we're sitting outside of the offices of the jobs that we pray to the heavens for. But for whatever reason, they're stressing us out at the moment. You're looking for a new job. Or, you're trying to keep up with inflation so you can get something other than white socks, which is either case. These are, some of the situations that we're trying to wrap our heads around and how we can rectify it. So Jordan is currently employed but considering a career change. Here's how Jordan begins seeking employment. So again, these are just ways that you seek employment. Engage in a negotiation. So Jordan attends a networking event and speaks with a hiring manager from another company. They discuss potential roles, salary expectations, and start dates. This counts as an employment negotiation because you're there with the employer, you're talking about prospective jobs, what the salaries could be. You're in an active negotiation with that employer. Another example of an unsolicited communication. So Jordan seeks a message on LinkedIn, sends a message on LinkedIn to a recruiter, and at a company he admires, expressing interest in future opportunities, even though no job was posted. This is an unsolicited outreach. He's seeking, a job with a prospective employer. And then also responding to a job inquiry. If a recruiter emails Jordan about a position, Jordan replies with interest and asks for more details. Even though Jordan didn't initiate the contact, his response, not a rejection, qualifies as seeking employment. Especially if they reached out on behalf of a particular company that you can identify and they're saying that you may be a good fit for this role. That would be, seeking employment. So so how do we get around this in in our official capacity? What happens or what should we do if an entity that we're seeking employment with is now on our desk for an official decision? What should we do in that situation? Anybody have an answer? Yes. Say it again. Yes, recuse. So recuse. Now I put this picture here up. You might not get the contact uh, right off the bat, but I used her because in my experience, she reminds me of a woman who is not going to answer your question. Uh, she has she has recused herself from the situation, and so though you don't have to be this mean in your employment, right? You don't have to be that mean. But essentially, if the prospective employer comes across your desk for an official decision, you need to recuse, right? You don't want to make any official decisions regarding that entity, nor should you try to promote any favorable decisions, for the from someone else, from the prospective employer, behind the scenes. So an employment opportunity conflicts or appears to conflict with an employee's official government duties and responsibilities when a prospective employer has a particular matter in its office to which the employee is participating or has responsibility over. To avoid a conflict of interest or the appearance of a conflict, an employee must recuse from participating in a particular matter if their participation will likely have a direct and predictable effect on the financial interests of a prospective employee. So yeah, that come up in many ways. You are seeking a new position. See here, what's a good example where I don't bring up something that actually happened? You're in a position and you award contracts to certain vendors. So you're in a position where you're the final approval for a vendor. One of the vendors on the list is a company that you apply for, and you might not even have been applying for any type of substantive work with that company that your office now does. It's a big company. They do many things, but you're looking for a job in a whole different field, but that vendor is there on that list seeking an official decision. When you see that, you have to recuse. You have to recuse from it, because even though you won't be supporting your office in that work that you're trying to do for that vendor, they're still party that you have interest in because you submitted an application. With that being said, you see that party there, you write it out an email, you send it to your supervisor or superior, and just let them know, hey, I have a potential conflict of interest with this party. I have to recuse myself from making this decision, and then they have to assign that decision to someone else. With that being said, once they assign the decision to someone else, I see a question. Once they assign that decision to someone else, you cannot sign off on anything regarding, that potential conflict of interest. So even though someone else votes on it or approves it, or it goes through whatever channels it needs to go to for finals approval, even if you're the person who's authorized to final approve and signature or rubber stamp it or whatever may have you, you cannot be that signature. Somebody else needs to sign off on it because you're completely recused from that situation. Go ahead with your questions. Behind the pole.
What if recusal is that designates the like only
Yeah, I hear you. So the question is for people online who may not have heard is what if a person is the only signature or the only person by law or policy that is authorized to sign off on the particular matter. They still have to delegate it to someone else. Now you can get a waiver for some conflicts of interest. Maybe write the situation out and explain it and submit it to the Board of Ethics for review, and we can give or they can give or approve a waiver for that instance. But other than that, even when the law mandates a particular person is authorized to make this decision, there usually is some delegate that could be assigned for that matter. And even if they're signing on the behalf of that person, just the general counsel within the office, or just some chief of staff, just some other official who in that moment could be delegated to do. But absent that waiver, I wouldn't sign off on a matter that I have a conflict of interest. So again, recusal is accomplished by filing a written recusal and not participating in agency decisions that involve the prospective employees. It says here you must make full disclosure of the financial interest. You don't necessarily have to make a full disclosure, but just say, hey, I have a conflict of interest with this particular, party. So you name the party that you have a conflict of interest with. And just, just basically state that I recuse myself from this decision-making matter. And well, it left, but it just repeated what I said earlier. The supervisor or whoever has the responsibility now to assign that matter to someone else. Now, with that being said, sometimes our jobs are dedicated to like a case or profile of particular entities, and sometimes a recusal would cause a hang up in the office. Like, you're not able to do your job because you're recusing, so much. With that being said, don't apply for, 20 different employers at the same time where you have to, recuse from your whole casework, because then you're now ineffective, from your job. Try to space it out one at a time, because, basically it turns into like a personnel decision where like you're recused so much you can't even do your job. What do we need you for? So, just to, keep that in mind, that you have to do it in a certain way where you're still able to function in your work. Now, if you have, 100 different decisions or whatever, or cases, and then you have to recuse for one or two, that shouldn't match. Right. But, if you got, 30 different, vendors that you handle, and you're accusing from 26 of them, that's going to cause an issue. All right. So an example. Pretend like you don't see the last one there. So a policy analyst at the Department of Energy and Environment, if I said that right, the DOE gives a presentation at a regional sustainability summit. A few days later, she receives a message on LinkedIn from a recruiter who attended the event. The recruiter praises her work and mentions that several environmental consulting firms in the district are looking for experienced professionals like her. Two of those firms currently hold contracts with DOE. The analyst replies that she's open to new opportunities, and the recruiter then schedules a follow-up meeting to discuss potential roles and salary expectations. Is she seeking at that moment? That pretty much covers. And so let's see here. If he had any potential employers on her desk for official decision, does she have to recuse? You think so? So it's saying there's an intermediary. This is like a tricky question. So she is, sort of seeking, but like, who is she seeking employment from? Because she was at a summit. There's an intermediary there who's saying, hey, I've got some prospective employers for you. We should sit down and talk about it. who she doesn't know who to recuse from just yet. She doesn't know who the opportunities are with her just yet. So yeah, she's seeking, but she's not seeking with a particular party just yet, where she has to recuse from anything because it's an intermediary. You can probably see who they work for, the recruiter, like who they've placed candidates with before. Sometimes they have like a book of companies that they work with, but you don't know who she has the offer with or the potential job offer with just yet. So you can, just kind of hold out on having to recuse from anything in that situation. Example 2. So now the employee has spoke with the recruiter. The recruiter believes she would be a great fit for the bigger, better job company. The position that the recruiter identified for the employer pays $30,000 more in salary, and will propose the employee for that position. So she's gonna let the employer know that this person is a good fit. The bigger, better job company has contracts with the federal government and DC government, which includes contracts with the DOE. Now does the person have to recuse from those vendors' bid? Yeah, they submit the resignation. That they don't have to submit the resignation just yet, but they do. But they do have to recuse while the company mulls over the offers and they go through the interview process and things of that nature. But here, the company is identified, the bigger, better job company. We also have the salary. It's paying $30,000 more than what she's currently being paid. And so with that being said, she's in a negotiation, and the intermediary is speaking on behalf. She needs to recuse from any decisions regarding the bigger, better job company that comes before her death. All right. Got another question. Back there.
What level of knowledge? What level of knowledge does the employee have to have about the vendors? Let's say, for example, the vendor employee applies to the job is subsidiary of another company. And the employee has no idea that parent company has contracts with the district. But the parent company is wholly owned by the vendor. So essentially, the employee is seeking a job that is controlled by the district. Is it the employee's job? Oh, vendor that I'm seeking a job with, you have a relationship with the district, or is the employee doesn't?
All right. Congratulations on the newborn. So just to repeat the question to people who are listening online, if you didn't hear, is what if a vendor who you sought employment with is owned by a parent company that currently does, or now what should I say, a contractor, a company that you're seeking employment with is owned by a vendor that does some business with your agency. If you need to know, who owns the companies and whether or not you have a conflict of interest and can make a decision, while you're seeking employment. And that's a good question. I don't think we're going to fault you for stuff that you don't know about, right? So like if you applying for a job and you made an official decision regarding some other company, and then that some other company just happened to own that company that you've applied for a job for, that wouldn't necessarily be a violation, especially if you didn't know about it. Now, if you did know about it, to be on the safe side, I would recuse. Like if you do know that the parent company owns the company and that parent company is before you in decision-making matter, I would recuse it to be on the safe side. But I think a violation would occur is one, if you know about it, and then two, that relationship was apparent, or strong. And sometimes that's the case with smaller companies. But if it's a big company that owns a whole bunch of other companies, like we don't expect you to do that research, outright. But if you do know about it, you should, just recuse, because there's, appearance things and things of that nature. Small stuff can come look like a big scandal. So just avoiding the appearance issue. I will recuse from that if you know about it. And then as soon as you do not go,
Can I add something? I just wanted to add to that saying in the interview that you didn't know is probably not going to be good enough, right? Like, we hear that in almost every interview. Sorry for the poor sound. Yeah, sorry about that. The sound is poor. I can comment. It sounds very bad. But yes, just saying that you didn't know is not going to be enough, right? We have to do an investigation. And I mean, if it's in the investigation, it's clear to us, hold on, that you didn't know, right? Then, we might be able to let that go. But Maurice made a good point, right? There's a big conglomerate that owns a bunch of companies. We wouldn't expect you to know that one of these small subsidiaries that you're applying with is one of 20 companies owned by the conglomerate. However, should you have known, right? Like, is this something you could easily go and figure out on Google? We do want to encourage people to be thinking about these things and do some level of due diligence, and not just come into the interview and say that you didn't know. Because we're also looking at whether you should have known, right? It depends on who you are, who the company is. We had one that was kind of like this, and the person said they didn't know, but all of the email domains were from the bigger company. And it's like, well, you didn't know, but you're being emailed from the bigger company, right? Not the subsidiary that you applied with. So you should have known. So I don't want to make it seem like you can just come into the interview with us and say, I didn't know. We're going to say, okay, well, good luck in your new job. So it's a little bit more goes into that. Lynn, you said something. I'm sorry about this.
Yeah, so I wonder if that young or
So to know that there is this potential for a conflict, willful blindness is not okay. So you have to and ignore that domain and ignore the information that's on the website that says about us. We are a subsidiary of this other company.
and you are doing a you are doing that due diligence on your own. Whether they're that or conflict. So you can't just say, I'm not going to look past this. That's an interview, but not see. That is apparent.
I get what you're saying, but my question is, the standard by which an employee's evaluated, is it objective standard, or is Bacon going to look at how sophisticated the employee is? So I'm applying for a job as low-level maintenance worker in this corporation, subsidiary, big corporation that's work with the district, versus I'm applying as a general counsel. Is it the same standard as that? Website. The employee only have to
The potential for the conflict is very different, right? So what you need to know to assess is very different depending on the type of position that you're applying for, because what your official responsibilities for the district are, that's what determines that potential for a conflict of interest where who's applying. Your maintenance worker is unlikely to come into a situation where they need to know about your parent company, the company that they're trying to get. The general counsel, however, has to do that due diligence to assess the potential.
I will also say that for me, which should have, right? Directors, final managers, and general counsels. So and they're really smart people, and they should understand. And it should be at least on their radar to say, I'm doing this. Let me do it. Right? You should have heard of them. So that would be a part of
people who were online and may not have heard, the question was, what was the standard on, if a person should have known to recuse or not. And it is a reasonable standard. But with that being said, most of the people who would be in a decision-making, capacity, they usually are, more sophisticated or higher up, individuals. I wouldn't expect, a maintenance work to even need to recuse from anything. Uh, and it just depends on if they're, procuring, maintenance materials or something like that. And then they're, approving or buying the services from a company that they've applied, to. So in that case, maybe so. But yeah, we would expect you to at least look it up to see if there's any potential conflict of interest with other parties that might be affiliated with the person that you've applied for employment to. So example 4. A procurement officer at the Department of General Services receives a message from a former colleague who now works at a construction firm. The colleague mentions that their firm is expanding and looking for someone with government contracting experience. The officer expresses interest and they agree to meet for coffee to talk about the role. The construction firm is currently bidding on a major DGS project that the officer is indirectly involved in reviewing. Or how would you all navigate that situation? So he's indirectly, I think the question that the one of the main points is there is he's indirectly involved in review, right? So which parts are easy? Is he seeking? Yes, right. Does he have negotiations, on the horizon with this prospective employer? I would say yes. Is he in charge of approving, whatever it is that the construction company, does?
No.
Probably not. He's indirectly, involved. So he's probably not the person that signs off or ultimately approves. But in this situation, he shouldn't even be, behind the scenes, facilitating any type of, agreements or discussions that could potentially help out, his prospective employer. It might not be a seeking negotiate or conflict of interest violation, but it could be a public office for a private gain. And so if he has any financial conflict of interest, let's say he already worked for the individual, for the company, or like as some type of side job or his prospective employment, anything like that, he has that financial interest that is there. He shouldn't even help behind the scenes. So a lot of times this can happen where he might not have to do a written recusal because he's not making the decision, but he should let people know that, hey, when you bring up discussions regarding this entity, I'm going to stay, out of those, discussions. And then that happens. Because if it doesn't, and let's say he doesn't make, any official decision, doesn't sign off anything, isn't an approver, but, he looks up, he's putting in his resignation letter. Everybody at his current office is now seeing that he now works, for this company. And they just remember him just being all over the meeting saying, yeah, they're the best. They need to get this contract. And, I'm not voting for anybody, or I wouldn't, promote a vote for anybody else. And they recall all of that. And, they feel like, they were, directing to making this decision regarding this company that, he now works at. That's going to be, an issue. All right. So here's a case where that looks like, and I try to leave, names and things out so we could just kind of focus on, what happened and get the lesson from that rather than, re-digging up, embarrassment or, things of that nature. Because, these things could lead to, basically embarrassment. There's fines associated with, this type of conduct. And with those fines, there's public orders or negotiated dispositions that are, online and searchable for other people to go and learn the lesson as well. Like, oh, I can't do that. That's the fine for this type of conduct. Let me stay away from that. So with that being said, this is a piece of a situation that has occurred, and then there was a fine associated with it. So this subject was in negotiations with the prospective employer regarding a future job opportunity. During that time, there were substantive matters of the prospective employer pending before the subject's agency. The subject was directly involved in those matters. And in this case, the subject's agency decision was unfavorable to the prospective employer, but they were still seeking. They still made an official decision. They were involved in the matter. This did not negate that the seeking or negotiation for employment occurred, which conflicted with their employment. It was still a violation. The subject should have completely recused from the matter as soon as they entered into the employment negotiations. And then in that case, the subject was fined $2,500 for, approving a particular matter, even or making decision regarding a entity that he was seeking with, even though the decision was not favorable for the entity that he was seeking. It still is there. He should have just, recused from the situation altogether. And so again, I asked, is anybody seeking employment? If they want to share, their just kidding, you don't have to. But with that being said, if you're seeking employment, keep these things in mind, conflict of interest in mind, figure out who you're seeking a job with, whether or not they have contracts or business with their agency, and also who they may be owned by, and if they're having business with their agency, and just keep those things in mind. And situations like this with conflict of interest, they do touch on criminal matters as well. So it's like you want to stay as far from that line as possible.
I guess that's fine. So when somebody's seeking recusal on a particular matter, how much information do they divulge the reason for the recusal? Because I can see a lot of people not wanting to say, "Oh, well, I'm applying for this other job, or I'm looking to leave the agency, but I'm going to recuse myself because I'm doing that." I think most people want to go into a level of detail without having a hard offer on the table.
Yeah, I can understand that. That's what I say. You name the party that you have the potential conflict of interest with, and you state that you have, a financial interest, in that employer. And I believe that covers it. Financial interest could be, yes, you're seeking a job with them, or it could be I'm invested with them, or my spouse is invested with them. But yeah, the main thing is to put it in writing, because you want it in writing, and then also just to make sure that you stay out of the decision making, arena with that party altogether.
So my question might be for the next session, but so in the positions that I've held, I've never done anything with any actual contracts or grants reviewing or management, but I've done work across the agency, work across agencies. So even though I'm not a decision maker, I could potentially be considered an influencer. If people know stuff that's been happening sort of with a nonprofit or for-profit, so on and so forth. So because there's no decision making aspect, that would not be a conflict of interest, I wouldn't think. But is there something else then that so if I'm in an agency, I'm not actually looking for employment, I'm just thinking that, yeah. So if I'm in an agency and let's say there's a nonprofit that my agency works with that I may work with, but I'm not in the part of the agency where they get their grant. Is there any what else might I need to consider if it's not conflict of interest?
And so I think that was loud enough so people online should have been able to hear you. So with that being said, I would pay attention to public office for private gain, because you don't want to be accused for steering contracts, toward, a vendor in which you're financially interested in. And so and you bring up a good point, because it could be nonprofits that you're associated with. If you're just a volunteer for that nonprofit, it's fine to some degree to say, hey, I have some knowledge of this nonprofit, and, I believe that they would do, good work when you're looking for other agencies. But if you're sitting on the board for that nonprofit, like you're in some type of fiduciary capacity, then you don't want to do those things. You don't want to promote, the 501c3 that you sit on the board for in meetings with DC government and influence them to make decisions toward them. So applying for jobs with them and then sitting on boards with them or having some type of fiduciary duty with that nonprofit, you want to lay out of those discussions, because you could be accused of steering, contracts or, public office or private gain, which you're, causing awards to parties that you're financially interested in. And the financial interest is imputed even when you're in a volunteer role, but you sit on the board.
Maurice, I also just wanted to point out that in the conflicts of interest statute, there's more than just decision making, right? There's several different categories of participation that you could engage in that would potentially trigger that conflict of interest. So, and you may have had it up there in your presentation, the entire definition of a conflict of interest, but you could participate in some other way other than making the final decision that could still be a potential conflict of interest.
Question?
Would it be fair to say that mostly when we're dealing with private sector, we should do these steps? Although I believe you mentioned nonprofits or nonprofit, right?
Yeah.
But it's mostly with private sector where we're seeing employment with the private sector that this would apply. Am I correct?
Yeah, so private corporations, nonprofits, anything that's not the government is going to be considered, private, and then those have potential conflict of interest. Now, when you're in liaison with another government office, there's no conflict of interest there because it's, it's government. So like, if you're seeking a job with a Maryland government office and you're in your DC job, but for whatever reason, your office may have some type of correspondence because you share an issue along the DC border, or, have a close issue in hand. So those, if you're making decisions that are on behalf of that would benefit Maryland government, that's not a conflict of interest, right? But if it's any type of non-government entity, then that would be a conflict. And then also any contracts. So like, let's say they do Maryland business or they do federal government business, but it's a private contractor that's doing it, that's still going to fall in the conflict of interest, realm because it's private. You get it? Any other questions? All right. So if you do have some seeking advice that you just need to get from us, you can contact us at vega@dc.gov. You can also contact me at my email. I'll leave it in the chat. And with that being said, if you were too shy to ask a question here, which I understand if you're sitting right next to your boss, you can go ahead and email me and I can give you advice there. And it is confidential. It is between, us and you. And it is always good to seek advice because we give you safe harbor protection. So if we told you that you could be involved in the decision, that wasn't necessarily a conflict, or that seeking is okay, and you go ahead and you do that, but it turns out later there was some nuance that we didn't consider, and that is a violation. Like, you may have to get out of those official, decisions regarding that, but you wouldn't be fined because we told you that it was okay. So just go ahead and ask us advice first. We'll help you navigate the situation, and we'll also give you some post-employment advice on the spot there too, because that's another thing to bring up when you are seeking jobs. So sometimes that employer wants you because you work for the government. I don't know why we got an echo. So that employer wants you because you work for the government. Right. So they're expecting you to be able to do things or communicate with the government right when you start working with them sometimes. And that's just not the case. So, a lot of times that new employment could lead up to you violating some post-employment restrictions, and you should seek advice regarding that as well. I will let you get back to your lives.
Thank you, Maurice. All right, thank you, everyone. We are on a break.